Hi and welcome everyone to CITI Network event on intellectual property. I'm Sarah Williams, I'm a GP by background and recently joined CITI as a clinical fellow in innovation for Nadine Hajjaj-Haram, who is the Director of Innovation and Strategic Partnerships. Some of you will have joined us before, for some of you this will be the first time. So let me just give a quick introduction to what CITI is. CITI is the Centre for Innovation, Transformation and Improvement here at Guy's and St Thomas Hospital, headed up by Lawrence Talon, the Deputy Chief Exec. CITI is all about facilitating change and making ideas happen in the Trust. And one of the ways we want to do that is through developing a network of change makers, people like you all who are passionate about making things better for patients. Always patient health at the end of the day is what we care about. So today's event is about giving information and teaching, but it's also about getting to know you. And we really hope these events will kind of inspire and enable you, and that you can get to know some of us here in CITI and some of the people that we work with to be able to help you make your ideas into reality. We know there are lots of our staff who have amazing insight into ways we can improve care for our patients, whether through improvements to existing care, a change in service, or a new idea for a product. We don't want those ideas to get lost because people don't know where to go with them. So we want to empower you and help you navigate through any barriers. And we also, like I said, want to provide technical skills and knowledge, and we're well able to do that with a whole host of experts, thankfully, here in GSTT. So today's topic is the last in our three-part series on intellectual property. And the reason I say thankful to have a host of experts is because as a clinician, this is something I did not have a good idea about and didn't really understand the importance of it. But now I can see how essential it is really for anyone thinking of developing something within the health sphere, and a real sometimes just a basic knowledge and sometimes a real expert knowledge is really valuable. I'd love to see more people hear more about it. So I hope those of you who have joined this evening are telling others and sharing the news. So as I said, it's the third in the series, and we have Tas Gohir, who is our Senior IP and Commercial Research Manager, and he'll be introducing his guests this evening. So I really hope you enjoy and learn a lot, and we hope to hear from you in the future as well. Thank you.
Thank you, Sarah. Hello all, and welcome to this third and final part of the IP webinar series, as Sarah just mentioned. During the last webinar, we focused specifically on patents. This evening, we're going to be covering other non-patent forms of IP. And towards the end of the webinar, we will also be presenting a case study known as the post-surgical vest, which is based on the work of Melissa Rochon. And interestingly, this particular innovation has been protected both by patent and design rights. So it's my pleasure today to have Emma Bridgland, who's an attorney based at Venner Shipley, join us, and also Melissa as well herself, and she'll be talking about the post-surgical vest too. So welcome both, and thank you so much for making the time and giving your time today. So I'm Tas Gohir. I'm the Senior IP and Commercial Research Manager within GSTT, and I sit within the Commercial Innovations team within CITI. So Melissa, if you could perhaps give a little bit of background to yourself as well, please.
Thanks, Tas. Good evening, everyone. So I'm Melissa Rochon, and I'm actually now leading on an extended role trust-wide. So my new role is Trust Lead for Surveillance and Innovation, as well as Research. So a bit of a longer title, I suppose. And I'm really pleased to be along this evening. With surveillance, it's much about preventing surgical site infections, and it's really strange to be attending as an innovator or somebody who's worked with patents or design rights this evening, but it's an absolute pleasure to be here and share what experience we've had to date. Thank you.
Thank you very much, Melissa. I'll start off by talking about know-how and trade secrets. And know-how is really quite important in the sense that a lot of people don't appreciate its importance working within the scientific community, in the sense that it forms the basis of our know-how, the underlying knowledge that we have in the background, which may be unique to us, and it often forms the basis of specialized work that academics and clinicians do in terms of consultancy. And then know-how and trademark, know-hows and trademark don't need to be registered at all. They're an alternative form of IP protection compared to patents. And one of the things they do is that you basically don't disclose what your trade secrets are, what that know-how is, and that's how it's protected. And one of the advantages of that is that it prevents people, say, from reverse engineering any of your products. Know-how, trade secrets, particularly know-how can be licensed in any other form of IPs, including patents. And as I mentioned, it often forms the basis of consultancy work. It is a powerful and often extensively used means of IP protection by companies who simply want to protect by not disclosing what their specialist knowledge is. And if you file a patent, then there comes a time when that information is disclosed. So organizations and typically Formula One engines, for example, and Coca-Cola don't disclose the underlying IP and simply just protect it. So that's an overview of know-how and trade secrets. The other aspect I wanted to look at, briefly talk about, was copyright. Copyright it protects the expression of ideas. It doesn't protect the idea itself, but the way that an idea is expressed. It can take a literary form, drama, music, or artistic. Ownership is immediately upon creation, so there's no need to register it. And as long as you have an audit trail to show that you are the creator, so if there's ever any questions about who created that piece of copyright, then at least an audit trail will prove that you are the creator. And one of the things I often cite as an example of how this is important is when authors write a book, they will often post chapters to themselves, which is stamp marked by an independent, obviously, postal company, and not open it and not open that envelope once it's delivered to them with a date on there, which then, if there's any questions about ownership of who wrote that chapter, they can open the envelope and there is a date mark which acts as an audit trail. It's important to whenever any copyright material is created, and in the case of GSCT, this copyright material could be templates or forms of it, with questionnaires, etc. It is important to put the copyright mark on and state the ownership as GSCT and the year it was created. It's not absolutely essential. It's not legally required, but it is good practice, so that people know who the creator is. The other form of IP I wanted to mention was trademarks. And yeah, just briefly about trademarks. These are symbols, words, which are effectively protect the brand, and do require registration. They protect logos and words, and that is something which I believe Melissa is considering for her surgical vest too as well. So maybe Melissa, you could talk about your thoughts on IP protection, because you've been through the process of the patent process and also the design rights protection. I know you're considering trademark protection too.
Thanks, Tas. Yes, I think just given the sort of breadth of different sorts of claims and rights, it can be a bit confusing in the world of IP. And it's a shame, really, because frontline colleagues, I'm sure you'll agree, are absolutely perfectly positioned to innovate. And in this context, we really mean about developing a product or a process that you can actually commercialize. But if we don't have access to this information, we might actually jeopardize the project. And I think that earlier on you mentioned about, that we had registered for a patent as well as design rights. And in the NHS, we're really keen to share our ideas. And it's not natural, really, to sort of wait to go through all the paperwork and the processing and keep things quiet until then. But you're asking about trademarks. And I think this is in particular one area potentially which, on reflection, I'd like to go back, revisit and do better. I think that I was in such a hurry to focus on things like the patent that the trademark really fell by the wayside. And by that, I mean, I didn't really appreciate how much of a brand it is, that it will represent you outside of the organization. And you really want something that people are going to remember and something that means something in the context that you're working. So as an example, our first sort of innovation, we called the BIS, which was a Brompton Harefield infection score. Very powerful internally, less powerful externally. And if I was to go back again, I would have tried out the name with patients, with colleagues, to see how it landed. As well, I think that sometimes when you're looking for trademark identities, you can be led by what's used usually within the organization, and that is very useful. So we had some great colors associated with our trademark. But yes, that's an area where I think that I probably should have paid more attention to. And I don't know if you've come across similar, where people hurry the trademark as a sort of last thought. They're more excited about potentially the patent. I don't know if that's been your experience.
Yes, that is my experience. I think you're right in that, and totally that the patent is important because it is the strongest form of IP protection. So I guess that's why people will focus on that, and trademarks and other forms. They provide protection, but obviously not as strong as a patent. But certainly in terms of branding and creating the message in the market, then I think trademarks do require greater thought and the image that you want to create. Absolutely,
And this is something CITI can help with as well, isn't it? Because I know with the Cats Fest, actually, when I was finding out about design rights and patent and everything else, trademark was something also I could go to you for advice on. It
is. So we can provide. We work with with innovators right across the trust, early stage ideas to more advanced ones, and help them with IP protection and commercialization. And if commercialization isn't appropriate, there may be other forms of dissemination. We will advise how best to develop and disseminate and get that innovation out there, because it is all about what is the impact that we can have on patients, broader society as well. Absolutely, Maybe you could say a little bit about your particular invention with the post-surgical vest. A little bit of how that idea came and your experiences developing and protecting it.
Terrific. Yes, great. So in the past, we'd actually developed another product, a surgical bra for ladies after cardiac surgery. So we had some experience within the space. I think that when we were looking at the literature around chest support, it was suggesting that, in fact, there was some benefit. You could potentially prevent deep surgical wound infections if you had appropriate support. But what we found was a lot of the existing models weren't particularly comfortable, so there was an issue around compliance. What we did differently with the Cats Fest to the BIS bra was we decided to work collaboratively. That was, we decided to innovate with colleagues from other centres, so Oxford and Barts in this instance. And we did that for a number of reasons, but obviously along with collaboration becomes a whole other set of documents and assignments and contracts to work through. But we found it really useful and powerful to work with different experts with different perceptions or priorities in their field. And we started, I think, in 2019 with the idea that we were simply going to improve the comfort of these chest supports. We were hit by COVID, so there were things that were put on hold during the project, but we were delighted to be able to move through to clinical evaluation over the last year, and that was done with CITI's input. So as sort of a start point, when you're designing what could be considered a medical device, you need to make sure that you're fulfilling the tolerability and safety for patients appropriately. So CITI colleagues kindly progressed us through the review of what our purpose was for the garment, and we then had advice on what would be appropriate for the clinical evaluation, which was tremendous because I don't think I'd know how to go about it otherwise. So throughout the course, I think there's still a lot of learning. I knew from beforehand that it was important to keep sort of track of the different prototypes. But I think too, I've learned over the course of the last few years, transparency is incredibly important. So when you're developing something that potentially could be patentable or could, ultimately lead to a revenue stream, you need to distinguish between who had input in a meaningful way to the function, let's say, of the garment versus colleagues who potentially helped with testing, and to make sure that sort of throughout the process, everyone understood where the product was at and where it was going and how they were helping and what did that mean for their department or area. Because I think with innovation, it's incredibly useful to share and to promote others and their input. So for me, it's been, I don't want to say a straightforward process, but potentially we were fortunate that we didn't have to go back to the drawing board too many times, that we sort of knew who our supplier would be, who our manufacturer would be, which is a big part of it as well. When you're doing prototypes, who's helping you with this design process? And I think too, having CITI on board to help with all of the different, trademarks, design rights, patents, licensing agreements. I mean, the list goes on in terms of how I've exploited your help, Tas.
No,
so,
no, it's been a pleasure working with you over the course of this project. If I can also ask Melissa, in terms of the process that you've been through, what are the key things? What are a couple of key things that perhaps you've learned along the way that you think you'd like to, to sort of say to other people might benefit from your experience? If there were a couple of points, what would they be?
I think firstly, get in contact with CITI or similar, so tap into the legal advice, because it will potentially stop you from putting a foot wrong that could compromise the project. And here we talked about the idea of a patent and not sharing outside of the organization. Actually, what had happened was we were putting into a conference, and an international conference, before actually filing the patent. And luckily we were pulled back from that point. But that steer is so important. And like you say, it's not just about, are you going to, ultimately have a patent? It's how can you disseminate meaningfully? So when you tap in early to people who have the know-how to help sort of adapt, adopt, sustain your project, that's going to be really powerful too. So get in touch with the experts early would be my number one go-to. I think I've mentioned already just the trademark. It's a little bit like having a degree with a patent. Nobody really asks much about it. They're really looking at the impact it's had. So how do you show that that's your brand and what you're trying to achieve. And that's really, it's a very visual thing, and it can be quite powerful. So spend a bit more time, I would suggest, on things like the trademark, as well as, you know, other things like design rights. And then for me personally, from my perspective, I think that there's a fantastic sort of reputational element to having a patent. But on reflection, I probably wouldn't have run so fast to file in Europe because of the additional costs. So just being practical. Yeah.
Okay. No, sure. Yeah, the costs, you have to be mindful of the costs, because they, especially with patents, they can accelerate considerably. Melissa, it's also be interesting. What's the current status of the project now, in terms of developing it further? What are your plans taking it forward?
So we've successfully filed for the patent and the design rights, which is terrific. I think with the design rights, it's very much around the looks and the feel of the product, and I think that was important to what we were trying to achieve with it. We're currently going through the assign rights, which is effectively saying who has what and why and where will they use this, together with our partner organizations. And once that's done, we'll be looking at the licensing agreement with our manufacturer and supplier. But the really terrific position to be in at the moment is, because we already had one sort of chest support device, we're already on the NHS supply chain. And I think when you're working from concept through product development to get it to the NHS supply chain, that is in itself like a huge ambition of mine to get there. And we have sort of a shortcut because we have one product already in the field. So the next step, I hope, is successful launch on the supply chain. But we'll see how we go. Hey.
Fantastic. That's fantastic. Yeah. That's, you know, that you've gone to the journey all the way from protecting the IP very early and nearly licensing it to a commercial partner. So that is great process. I'll just say a little bit while we're in the subject of the vest, say a little bit about design rights themselves for those that are not aware. So design rights, they are rights which cover the appearance of whole or a part of a product. They protect the way something looks rather than how it works. How something works is usually protected by a patent. So design rights protect appearance, shape, configuration, and even decorations around a particular object. And the key thing is that they must exhibit a sufficient level of individual character. You know, so that is what they're trying to protect. They can be registered and unregistered design rights. The registered ones are obviously stronger in the sense that, you know, they are registered, formally registered, and they give you protection for 25 years, while the unregistered ones, they're still valid, but obviously they're more open to challenge in the future, and they give protection for 15 years. And design rights can often go hand in hand with copyright too, so it's important to consider that aspect as well. So, for example, a trademark can also be have copyright protection too. One of the other things I wanted to mention was the design rights as well. Not design rights, database rights. My apologies. Because these databases, obviously there's a lot of data within GSCT and other NHS trusts, and it's important for us to think about protecting the IP around those, you know, so that we can utilize them to the best effect in terms of extracting the best value from them. The definition of a database is the formal definition is a collection of independent works, data, and other material arranged in a systematic or methodological way, and can be individually accessible by electronic or other means. So that's the definition. And I think if you are developing or working on a database, it is important to consider how you can protect it. And it's slightly different from other forms of IP in the sense that it's not necessarily owned by the creator of the IP. It's actually owned by the entity which makes the most substantial investment in the development of that database, i.e. one that takes the most substantial risk in creating the database. It's not about generating the data itself. And that investment can be financial, human, or technical. It can be all of those. So it's not automatically the creator as the inventor, as in the case of other forms of IP, but the one who puts in the takes the most risk. And protection is on databases is 15 years as well. So I thought I'd emphasize databases because I think obviously that they're really important to the NHS with so much data within the organisation. Just talking about your case study again, Melissa. We obviously filed a patent first, and then a design right. One of the things I wanted to sort of emphasize, the reason for doing that is because patents give much more stronger IP protection, and therefore it was always important to file the patent first, so we can secure the strongest form of protection as early as possible, and then we can think about other things. And we went on to design rights, and we're now obviously thinking of trademarks. And so there is a logical order. In following that, but of course your point that you raised earlier on is the importance of considering the others, and is to put enough emphasis on the others as well. The trademark is just as important ultimately in the marketplace as the patent, for different reasons. The patent is there so to protect the technology, but the trademark is there to really penetrate the market and create that market awareness, etc. So there is a logical order why we did that. And the other point that you raised, that this particular case study is a collaboration with BART and Oxford University Hospitals, and you mentioned that creates complications in its own right, but complications I think in a good way, because I think it's good to collaborate. Obviously it's good to collaborate, and because you get the most value that way. But it does mean that a lot of thought needs to be given into how that collaboration is then developed commercially, the collaboration agreements, how future revenues are shared, how inventorship. So we've covered a few things, Emma, but we've spoken quite extensively about Melissa's case study. But maybe we could just start a little bit, talking from your point of view. Obviously, you work with an extensive client base. You deal with a lot of different types of IP protection. One question I'd like to ask you, based on all your work experience and the organisations and people you work with, what are the main reasons, from your point of view, that companies actually protect the IP? What are the underlying reasons for doing that ultimately?
Yeah, so first of all, hello everybody, very sorry for the late start, but I've eventually made it, and we can all talk about IP now till the cows come home. So there are lots of different reasons that you might want to file IP. It depends who you are as a person, whether you're an individual, whether you are part of a trust, whether you are a business. And one reason would be to, which I think most people do, is to exclude other people from sort of competing products in the market. Essentially, if you've spent time and effort in developing your product, your invention, your brand, you've invested money, you've invested resources. You don't want somebody to come along and be able to just do what you're doing, having not invested all that time, having not invested all that money. So filing IP rights is a way of stopping other people from doing that. Another reason would be, if you have a particular competitor and you found a way of doing something similar, you know, you both work in the same field, you found a way of doing it more efficiently or a less expensive way. Again, you've invested all that time and money, you know, you want to get the benefit of that. You don't want somebody to be able to come in and undercut you on cost because of where they're located or something like that, when they haven't, again, put in that time and resources. And also it can add value to your business. You know, an IP can make the sale of your business more valuable because of the huge portfolio of IP you have, but also you can generate additional kind of revenue by assigning your IP rights or licensing them for a royalty, and it may be that you've got an IP right that you're not going to commercialize yourself, but you know it will be valuable to somebody else, and then you can assign it to them. And then I know it's not so relevant for trusts, but there is also the patent box scheme for people who do pay corporation tax, so may be useful for a spin out or something like that, who is going to have to pay corporation tax. If you have a UK patent, then you can get a reduction to your corporation tax for profits on that patent.
Sure, well, that's great. So I've already briefly mentioned that the main forms of non-patent IP would be know-how and trade secrets, copyright, design rights, database rights. Those are some of the key ones. Just briefly taking those each one in turn, probably more briefly than we've done otherwise. Can we maybe just starting off with know-how first? If you could say a little bit about your experience on know-how. I think that would be useful because that's probably the least known of the types of non-patentable IP and the importance and relevance of that.
Yeah, so know-how and trade secrets kind of come part and parcel. Know-how is confidential information together with accumulated skills. For example, you know, the recipe of Coca-Cola. There are lots of different types of Coca-Cola out there. There's roller cola, Pepsi, you know, all these different types that all are cola, but they don't have that same recipe. They don't have that same ingredient. No one knows the process. It's kept as a secret. And despite all these different cola products on the market, some of which may taste exactly the same, Coca-Cola still remains the most popular. A trade secret is something which is not known to the public, so therefore the owner of that trade secret gets some sort of benefit or economic benefit by holding it as a secret. So for a patent, 18 months after filing your patent application, it's going to get published. The same with a registered design, it's going to get published, but actually there may be a benefit in you keeping something entirely secret. So unlike other forms of IP, there isn't really one single individual who is an owner of a trade secret. It probably tends to be shared amongst a lot of people within a business or an enterprise. You do need to have procedures or things in place to keep it confidential for it to be able to be considered a trade secret. So it doesn't just arise. You do actually have to make an effort to keep it secret for it to be a trade secret.
Sure. And just to emphasize the relevance of know-how in the context of organizations, and in particular the work we do at GSTT, is that we can undertake consultancy based on our specialist know-how. We don't have to give away the basic knowledge. We can simply do work based on that without giving away the key knowledge that we have, but expand our consultancy work. Just moving on to database rights. If you could say a little bit about that, Emma, because the NHS, GSTT, we have a lot of data, and we do need to think about database rights and to understand how we can best extract value from that. So I think a little bit about that would be really useful too.
Yeah, so a database is actually defined for database rights. So it's defined as a collection of independent works, data or other materials which are arranged in a systematic or methodical way and individually accessible by electronic or other means. And it can actually be protected by copyright or by database rights, the database directive. So copyright protects the sort of selection or arrangement of the materials in the database where it's original. Whereas database rights protect the content of that database. So it doesn't have to be original for it to qualify for database rights, but there does need to have been a substantial investment in either obtaining, verifying or presenting that data. And substantial investment isn't necessarily money, it could be time, it could be effort, it could be resources. And substantial means substantial in terms of quantity or quality. So it's quite difficult to prove or show that that substantial investment has been made so that you can benefit from these database rights. But they do arise automatically as soon as the database exists in a recorded form. They last for 15 years from the end of the calendar year in which the database was made or completed. But in terms of the duration, there is a benefit in that if once you've created the database once, if you then make a substantial investment again into that same database, you get a further 15-year term if it can be shown that this substantial investment has happened.
Thank you for that. Now just turning to design rights, because this is you worked with Melissa in protecting her vest in terms of design rights. There's registered and unregistered design rights. It'd be great if you could just cover those and maybe speak in terms of how they were applied in the case of the post-surgical vest, the principles behind that.
Yeah, have you discussed the vest already? Sort of an overview of the vest.
Well, we didn't actually look at there is a slide which describes the vest, so it'd be good to maybe put that up, actually. Yes, to put that up this time. We just discussed it in more general terms.
Yeah, if I talk briefly about what registered and unregistered are, we can get that slide up and be a bit more specific. So there's unregistered design right, which does not require registration, and registered, which does. UK unregistered design right does not subsist until a design has been recorded or an article has been made to the design. And in the UK, there's this further criteria that you have to be a qualifying person. And a qualifying person is a citizen or resident of the UK. Also, if you are a business who is formed in the UK or has substantial activity within the UK, then you can also be considered a qualifying person. But if you are a German resident, you work for a US company, then you are not going to be eligible for UK unregistered design right. It's very specific to the UK. Other jurisdictions don't necessarily have this sort of qualifying person criteria. For example, Europe does not have this qualifying person. It's quite unique to the UK. You need to be able to prove the date on which the design was first recorded or an article was first made. This can be certified and kept by an IP attorney or a solicitor, but that is not necessary. You just need to find some way of proving the date on which you first recorded this design. They carry a maximum term. It's quite long-winded. We all have to learn it for taking our designs. It's a bit of a mouthful, I'm sorry, but it is the end. It's the earlier of 15 years from the end of the calendar year in which a design was first recorded, or 10 years from the end of the calendar year in which an article was first sold. And within that, licenses of right are available in the last 5 years. So that means if you have the 10-year duration, only 5 years of that will be your rights in the last 5 years. Anyone who asks for a license needs to be approved for one. And since Brexit, there is also what we call a supplementary unregistered design right available in the UK. It's new and it's purely just mirroring the European unregistered design right provisions, but because there are some differences between the two. So it only lasts 3 years. One of the differences is you don't have to be a qualifying person. I won't go into it in detail because we are running through on time, but if you have any questions about it, feel free to ask me another time. the main thing about unregistered designs is that you cannot protect surface decoration, a method of principle or construction, or some common things to both, like protected symbols, or anything that must fit. So like a plug and socket, the pins of a plug are not protectable by unregistered design because they must fit into the socket. There are other exclusions as well, but I'll skip through those. So registered designs protect the whole or part of a product, which can result from colours, lines, contours, shape, texture, but also 2D ornamentation of it. So unregistered design rights don't protect 2D ornamentation. There are lots of things that can be considered a product, so eligible for registration. So any industrial or handicraft item, including parts intended to be assembled into a complex product, which is 2 or more parts that allow assembly or disassembly. And it can be packaging, get-up, typographic typefaces, graphic symbols. It does exclude computer programs because it's covered by software, and they sort of try and avoid any kind of crossover. Software is covered by copyright, and they're trying to avoid any crossover. But although computer programs is listed as an exclusion, that doesn't include icons, app icons, animated icons, logos, graphical user interfaces of apps and websites. We actually register a lot of designs to these kind of things. It must be new and have individual character, and the maximum period is 25 years for protection. There's a couple of exemptions as well here. Anything, and which may be relevant to you, is that anything that is solely dictated by technical function cannot be protected by registered design. So if any thought has gone into how it looks, then it is registerable. But if it is entirely functional, then those particular features cannot be protected. There is, it must fit is also another exclusion which we talked about with unregistered design right. So again, the plug and socket, those pins of the plug will not be protectable by registered design as they must fit into the socket. But there is an exemption for registered designs. We call it the Lego exemption. It's not the technical term, but it basically means that any modular product, so a connection of mutually interchangeable products within a modular system, you are allowed to protect sort of vaguely functional features. So that sort of top face of a Lego block, obviously it's made to fit the piece above. Obviously it's made functional in terms of it's the thing that enables one thing to connect to another. But the Lego exemption means that those sorts of products can be protected with a registered design. And registered designs are a monopoly right, which unregistered design rights are not. So for unregistered design right, you must prove copying for another product to infringe. However, for registered designs, if something falls within your registered design, whether it's been copied or not, you are able to stop them. So I think if we get the slide up now with the Cats Fest on it, then Melissa can give us a little bit of an overview of a project, and we can kind of talk about that in terms of registered design rights.
Yeah.
Thanks, Emma. So I think with the Cats Fest, we were looking to keep it very simple. I think the key was that it should be comfortable, easy to fit and adjust. So what we landed on was a sort of a central torso band that could be easily fit with using a Velcro approach and a glove-like sort of fasten, if you will. So the patient's hand can actually go into the far side. As you can see, there's a bit of a pocket, and place that across for fit. The shoulder straps were adjustable too, and we decided to go with a pocket which would allow for different things, different items. It could be a telemetry box, it could be a battery pack for negative pressure dressing, also to be used with the vest, so something to help patients mobilize easily. So not a lot of bells and whistles, but what we felt was there were a few key things that were worth protecting with design rights, which I'll pass over to you, Emma.
So it's more about how to protect it overall. So I think Melissa mentioned they already had a patent filed to it, but there was something aesthetic about it as well that was able to be protected. So we would often file black line drawings without any colour or shading. This provides the broadest form of protection. We don't add any features that aren't essential, because every feature you add, every colour you add, every bit of shading you add narrows your design. So you actually want to file quite a basic form of your product so that lots of other things fall within the scope of that registered design. It's important to file your design once you know what the final design looks like, because the one that you're going to commercialise and the one that is actually going to be made available to the public, the one that you want to protect, because registered designs are much more narrow rights than a patent is, and the protection is provided solely by the drawings. Although we do include some words, we do file it under a certain category. You know, it is the drawings that show the protection. So we also use visual disclaimers to make sure that there are features that we don't want to form part of the design. So if the slide is up there at the moment, you may not be able to see, but the straps are made of like a breathable material that have lots of holes, sort of patterned holes in it. We didn't want to include that as part of the design, because what if somebody made it out of a different material that had a different pattern, or that didn't have a pattern at all? So we've shown that in dotted lines. Therefore, no matter what material is used, it is covered. And also we've shown the vest on the body of a person. We obviously don't want the person to be part of the design, so we've also shown them in dotted lines. You can also file multiple applications for registered designs, and the first article kind of has the most expense, and then to add additional articles in the UK and Europe is actually quite cost effective, really low cost to add articles. So you know, say the cat's vest had these really unique and distinctive colours, which it doesn't, but if it did, you could file your first article, black line drawings, no colours or shading, and then you could also file a second application for a minimal cost showing the colours, and that way you've got the broad protection of the line drawings, but also if you want the colours, you know, if you want them to form part of the design, if they are distinctive in any way, you may not want to only file the black line drawings. And then ownership. I think ownership is quite important as well for, especially when you're working within a trust, you might be working with lots of different people. There might be more than one person who's kind of come up with the design. So you need to know before you file your registered designs who owns it, and agree with assignments and things like that. You know, what names you're going to be filing the registration under.
Great. Thank you very much. Thank you very much. Anything else you want to add at all, Melissa, in terms of the case study, the design rights?
So I think you've mentioned already that the design rights were considerably quicker and faster than the patent process. And just to give listeners sort of an idea, Emma, to my mind, I feel like with my experience with patents, we've actually been right through to sort of the last hurrah, if you like. So it's taken years to go through that process, and it's quite expensive as well. To your mind, how long does it take usually to file for design rights? And in comparison, what's the sort of cost compared to just general ballpark for design rights versus patents?
Yeah, I mean, cost is very difficult to pin down, just because it depends on the complexity of both what the design would be and the patent. But a patent just in the UK is going to cost you thousands, and then you also need to consider every other jurisdiction that you want to enter, which is also going to be thousands, and jurisdictions you want to enter that have translation costs are even more thousands, whereas a registered design is sort of you know, what 1,000, maybe a couple of hundred depending, and the difference in time is patents do take years to grant. You also may not obtain a patent. You know, it has to be novel and inventive. You have to go through examination. It takes time, and you don't know what claim, so you don't know what scope of patent you're going to end up with in the end. Registered designs can take, they can be as quick as a few days, but a couple of weeks to a month or two. So, for example, the cat's vest registration, it's already registered, it's already enforceable, but the patent is still pending. The patent hasn't even started examination yet. So it's quite good to file both. You know, something I was going to talk about was the types of IP that cross over, and they don't tend to cross over that much, but there are lots of IP that you can put together in terms of complementary protection, and a patent and a registered design work very well. Because a patent takes so long, you may want to be able to enforce something earlier, and a registered design gives you that opportunity to do that.
Great, thank you very much. Thank you very much, Emma, Melissa. Another area that I wanted to cover today was the area of trademarks. I know obviously everyone's familiar with trademarks. So in our everyday life, we come across trademarks all the time. Emma, what would you say are the main objects that can be trademarked?
Yeah, so I think people recognise trademarks as logos and things like that. They sort of see them every day, words and logos, and these are both obviously very good examples of trademarks, but you could also file phrases, things like "I can't believe it's not butter" can be trademarked. Pictures, shapes, like the Toblerone bar shape has been trademarked. Sounds, so anything that's kind of known as a sound that's specific to a brand can sometimes be registered as well. So it's lots of things that are not just logos and words.
Okay, and how would you go about applying for trademark, and what are the key considerations at that point?
Yeah, so trademark rights can arise just through use and sort of reputation, but much stronger rights are granted by registration, and most trademarks that you come across are registered trademarks. Registration is territorial, the same as patents and registered designs. If you want protection in the UK, you need to follow UK trademark, but also they are in relation to particular goods or services. So where a registered design covers all products, as you know, as long as it looks the same, it covers all products. A trademark is specifically registered in relation to goods or services. So, for example, I think class 10 is to do with medical services, class 44 is to do with medical devices. So, you know, any trademarks that you'd be filing might fall within these kind of classes. Each class that you enter has an additional cost. So obviously people are just looking to register in the classes that they need to, but also trademarks require use. So if you don't use your trademark in the classes that you've filed them in, or if you don't use your trademark at all, then it can become vulnerable, and people can attack it. And so it's important to continue to use your mark. Registration can last forever if you continue to renew it as well. So provided you pay in force now, and that was registered in the 1870s. So
wait, Emma, we missed you. You froze for a few seconds. We missed the last thing you said.
Oh no, it might have been the best bit as well. Was it about registration can last forever? Yeah.
Yes, it was. Yes.
So it can last forever as long as you continue to renew it. So where patent has a 20-year kind of cut-off point, and registered designs 25 years, trademarks can last forever. So the first ever trademark that was ever registered, ever recorded, in the 1870s. I don't know if it's still enforced now, but it definitely was up until recently. So they can last for a really long time. Sorry.
No, don't carry on.
I was just going to give. I think it's quite useful to know what a good trademark is. So a good trademark is one which is distinctive and not descriptive. So, for example, Apple is very well known trademark for computers and phones and things like that. But in its very early stages, it would have not been allowed as a trademark for apples. You know, sporty wear is not a good trademark for sports clothing. And made-up words tend to be quite good because they obviously can't be descriptive, and they might be completely unique if you've actually made up a word, and they can be quite catchy. Like, you know, I'm sure Google was not a real word before Google came up with it.
Yeah, and what would you say are the common pitfalls of trademark registration?
I think one of the main ones is when I was talking about those classes, because I think you automatically go to the main classes that you think you're going to use. So if you're in a medical industry, you might just look to the medical classes, but actually it may be that you want to apply your logo to a t-shirt or to mugs or to something that you wouldn't necessarily think of originally. And years down the line, you may be creating these t-shirts and mugs with your logo on them, but you're not actually protected for clothing, and you're not actually protected for sort of dinnerware. So you may want to consider other classes that include these other products. So, if you're a band or a musician, merchandise, you might not consider filing under merchandise. I think also being too narrow. So I think most trademark attorneys, if you spoke to them, would always recommend that if you have a logo that you want to protect, that you would also file a word mark as well, just a simple text, not stylized in any way, shape or form. So for example, Coca-Cola, it obviously has quite a distinctive text with it, but you wouldn't want somebody to copy that same text and call it, Roller Cola. You still want to protect, so you would protect Coca-Cola as a word mark and as a logo, not just the logo. And use is quite a big one. I think people don't always know that you have to use it, so just think very carefully about the classes that you're registering and the use that you intend to do.
Yeah, okay. And in terms of what you've been saying, it's important to consider the cross-fertilization or the crossovers between different types of IP. And to bear that in mind. Could you just expand on that and the key areas where we should be thinking of crossovers?
Yeah, so I think I touched on that before in terms of like patents and design.
Yeah,
patents and designs are quite complementary. They're set. IP rights are set up in a way that there should be no crossover. But there's a lot of exclusions in lots of the different IP rights for software, and that is because copyright covers software. So they don't want there to be any crossover, but there is sort of complementary. So logos is one thing which you can file with a trademark. Trademarks are well known for logos, but you can also file a logo as a registered design, and there are benefits to both. A trademark lasts a lot longer. They're sort of the go-to for logos, but registered designs, although they have a shorter duration, they aren't then limited to a class of goods. So you've kind of got that broad protection for a shorter period of time. With the databases, obviously they can be protected with copyright or with database rights, but again, protecting different things, and then patents and designs.
Yeah, great. Actually, just to, as you mentioned databases again, one of the questions I wanted to ask you is when developing a database, how early on should people start thinking of the rights around databases?
I mean, not just for databases. I think all of these IP rights.
Yeah.
As soon as you come up with an idea that I would always assume that there is some sort of IP protection for the work. If you've put time and effort into doing something, I would assume that there is IP protection available for it. I would then probably speak to you, Tas, in the first instance, tell you the work I've been doing, ask your opinion, and then maybe speak to a patent attorney, a trademark attorney, a lawyer that has a lot of experience with database rights, and then get their opinion. Because I think more often than not, people think about patents and people think about trademarks, but they don't really think about the wider IP that's available. Yes. And also with things like patents, once you disclose your idea, so if that's an internal presentation that isn't confidential, if it's in an article on a website to promote the work that you're doing, or if it's in some kind of journal, people don't think of these as disclosures because they haven't sold it or they haven't marketed it in any way, but they are still made available to the public, and these disclosures can prevent you from getting a patent. There are grace periods for other types of IP, and disclosure is not such an issue for some, but if you're considering a patent at all, then these disclosures can be. So as early as possible, basically.
Yeah. Yeah, and I'll add to that is one question that inventors often come to me with. Well, I want to publish, so and then you know, then they sort of hesitate about protecting the IP because they want to publish quickly. And I always say that there's no conflict between publishing and protecting your IP. Both can be done in parallel. We just need to make sure that any IP is protected. For example, if it's patentable, it could be a day before the actual publication goes out. So as long as they work with me and coordinate with me, then both can be done. And often a patent, for example, is written based on a draft paper anyway. So even if you want to publish, it shouldn't exclude patent protection.
Yeah, and you can always file an initial filing with everything that you're going to talk about in your publication, and then you can do a follow-up filing within that first 12 months. And then when you come to the end of your priority period and you want to file foreign applications, you can actually claim priority back from the two applications. So there's always a way around it. Even if you need to publish tomorrow, you know, there's always a way, and any patent attorney should, or any IP professional should be able to work with you to make that happen.
Yeah, thank you. I don't think, Emma, since you've cut, I spoke about copyright before you came onto the webinar. I don't think we've covered that with you. We've covered everything else except copyright, I think.
I mean, I don't know if we'll have much more to add.
Yeah, I mean, if you could just give your perspective on copyright protection too. I think I may have already covered it, but it'd be good to you know, have your take on it too.
So it's something that rises automatically again. Lots of automatic rights that we've been talking about today, and it tends to be for the expression of an idea, not the idea itself. So where a patent is the idea, copyright is kind of the literary work, the artistic work, the photography, the software, the web content. What else can it be? It could be a sound, a music recording, film, even like a layout of a published work, or brochures and things like that. So there are lots of things that can be can have copyright. In the UK we don't register it. In other jurisdictions like the US there is some sort of registration that you can go through, but in the UK it arises automatically. You can mark your work with the copyright symbol, put your name and the year. Not marking it doesn't affect the level of protection you have, so it doesn't matter if you mark it or not. Just some people like to mark their work with that C in a circle, so that it's a bit of a keep off the grass sign that you have copyright.
Yeah.
It must be original. It's got very long duration, so different depending on what your copyright is for. But for an author of a literary work, it would be 70 years after the death of the author, so it's quite a long period of time. Sort of layouts of published editions is much less. I think it's only about 25 years, so it's different depending on what it is you have copyright in.
Yeah,
and it only protects against copying. Obviously, you have to prove that they've copied you.
Yeah, and of course it is, as you mentioned, it is owned upon creation. What I would say with sort of like copyright that would be created within the trust, it may be forms of questionnaires, etc. It is best to put a symbol on it and claim ownership as good practice. That's what I would still recommend, so everyone knows that who has created that.
And you asked earlier on, Tas, about reasons for filing IP, and actually that's one thing that I didn't touch on, which some people do just file it as a bit of a keep off the grass sign. Even if they think they're not going to get anything in the long run, or what they get is maybe not going to be that useful. What they have done is stopped somebody else from getting something similar because it's no longer new because they've published it. And someone can say, don't do this because I've got a pending patent application, or I've got some copyright.
Yeah, sure. And I guess actually just thinking of Melissa's surgical vest, there's bound to be copyright material as part of that as well. So we've patent protected it as a design right. There will be a trademark, and there will be training instructions, instructions of use, etc. And that will be copyright. And I guess you're working on that. I believe you're working on that, Melissa.
Yes, but I think that's a great point, is to just take sort of some of the comments from today and make sure they're transferring into practice. So right now, for instance, as part of the MHRA process, we're looking at instructions for fit or putting on the garment, let's say. And just to add that little bit of a copyright at the bottom, I think is quite useful, because it is part of our product and what we're going to produce. So yes, have to make sure it's protected appropriately.
So it demonstrates the importance of bringing together so many, the different forms of IP into one product, as a real example. We're nearly out of time, but Aidan, are there any questions in the last few minutes that we could address that have come through?
Yeah, sure. So I will pick one. So so one general question was, is there any research that exists to illustrate how much is lost in revenue from not licensing? So I suppose it's sort of anything on the opportunity cost.
That's a really interesting question. I don't have any figures, but I suspect it's large, especially from things coming out of the NHS and universities, etc. Emma, do you have any comments or figures on that? I imagine it's a big number.
Yeah, I mean, it's hard to quite quantify something that hasn't happened.
Yeah.
So I wouldn't have figures off the top of my head, but if you are able to license, why wouldn't you get that benefit from it? It seems a shame to have these missed opportunities when these things are all available to us.
Yeah, but what I do know and have experienced is companies picking up ideas from the NHS and universities, and where academics or inventors have inadvertently given away those ideas, and those companies have walked away and developed commercial products based on those ideas, and I think that happens quite extensively. So no figures, but I think it's a big number.
Thank you. I think there's another question, actually. I think it's more directed at Melissa about her next steps on the innovation journey as an entrepreneur.
The big question. I think that we've mentioned already there are certain sort of contractual agreements that need to get signed off and the like. But for me personally, I'm really keen to ensure that there are frontline clinicians, nurses, etc., that are getting involved in CITI, and how to do that really is sort of the big task at hand. And for me, one of the ways to do to spread innovation is to make sure that you're working with colleagues who are ward-based or bedside with patients, because certainly they are really well placed to innovate. I've already said this already. So it's about trying to take the great ideas that are there and helping to sort of bring people through, now that we have an accessible way of learning about IP as an example, and through to CITI, so that we can actually get some of these great ideas, whether they're products or processes, across the NHS, so that everyone benefits more broadly. So it's sort of one of those things, I think, that's in the CITI spirit. How do we get to, how can we encourage others? And I guess from my side, it's very much about making sure there's a sign saying, this way, if you have an idea, check out CITI.
Right. We've probably got time for one other question, I suspect.
Yeah, you've answered a lot of the questions actually already in the Q&A. I think the last one is kind of the good one to end on, which is, if someone watching this, how do they get in touch with you? How do they take the first steps in securing some sort of IP? Yeah,
so what I would say is to contact me or someone within CITI, the appropriate person within CITI. I'd be a good point of contact. And then depending on what your innovation is, we can help you progress it. But do contact CITI. And especially the commercials. If it's of commercial value, then certainly the commercial innovations team within CITI specifically. But having said that, there's a lot of innovations out there which are important for transformation and improvement of services, and they're just as important as commercially driven ones too.
Cool. Thanks. That's enough. That's all the questions we have.
Okay, great. Thank you. Well, I think we've run out of time. So thank you those who've listened in, and I hope the webinar was benefit is of benefit to those listening. Great to have you all. Okay, and thanks again, Melissa and Emma, and thanks Aidan for organising it.